Hello everyone, and today we will be going to discuss statutory interpretation. Though we have gone through a few of the, you can say, cases related to literal rule of interpretation, but I just want to make it clear before you that before entering into that domain, there are certain nitty-gritties which you must clearly understand. Otherwise, there might be some confusion regarding various aspects of interpretation. So first of all, you need to know why interpretation is required. What is difference between interpretation of a statute and interpretation of common law? Is there any, you can say, difference in approach taken by the judges? Then whether we are always aligned by the intention of the parliament, which we always justify that what the courts are doing, they are just getting into the intention of the parliament by having different rules of interpretation. And then what is the meaning of the intention, and what is the meaning of other stuffs which are playing a major role in interpretation of statutes. The other thing is what is the difference between interpretation and construction, and how you can apply that, and whether judges are being given that free hand that they can go to any extent to bring in something very, very new while making the interpretation, or they are limited to something, they are limited to some rigid rules, and how the courts were practicing this kind of things that we have to take care of, because sometimes we think that there is a clear boundary between all these rules of interpretation, and it is being properly applied and there is no confusion as such. So this is a kind of fallacy. This is not a very true story, because sometimes you will find that the judges are also human beings, they are fallible. So sometimes they apply a kind of, you can say, interpretation which you wonder that why it should be, why it has been applied. And sometimes there are so many aspects of interpretation which comes to a particular case. So to avoid all these kind of confusions, one must start with the basic. So in today's lecture, we will be getting through the basic concept of interpretation and how it has been carried forward by our judges. And before that, because we are going to the conceptual framework of statutory interpretation, since we have been inheriting British system, so we have to pay heed how they were doing that, how they started that. So for that very sake, we will just start why we need interpretation of a statute. So how the statute could be made, you already know that it is being made by a competent authority, that is usually a legislature, and they draft rules, they draft the law after having all these procedure on, and after that, because of some sort of, you can say, to apply it properly, to derive proper meaning, you need some competent authority to do that. So the authority which is being recognized here is judiciary, which must look into it, and according to situation, it interprets that very law to make it more viably applicable in the society. So whether this very rule book, or you can say the legislative framework which is being provided by the legislature, whether courts can do whatever they want to mess with this very draft, or they are always doing something which is very, very much subjected to this very document. This is a very tricky thing. So how that could happen, we have to discuss. So as you know, in common law countries, judgments also play a very important role. So while interpreting those judgments, or you can say getting through the common law, the judges are exercising a great deal of autonomy as compared to when it comes to the interpretation of the written, you can say, law, that is a statute. So they are a little bit obliged to that very writing which is being provided to them in that sense. So the law applicable to the facts of a dispute may be contained in an act of parliament, and knowing the law then involves interpreting a legislative text. So if you compare it with the case law, where judges construct their own texts out of precedents by catching up the ratio decidendi, With a statute law, the texts are presented to them. They are just placed before them, that you must go through it likewise. So that is not that much autonomous as it comes to the common law interpretation or the interpretation of the judgments. So you can say this is two different kind of approaches which judges maintain when it comes to statute and the common law, which is based on the you can say cases. So legislation may be also described as law made deliberately in a set form by an authority which the courts have accepted as competent to exercise that function. So as you know, this is a little later development when the state was fully established and the various organs of the state were fully, you can say, mechanized. Then we started, interpreting the legislation. Legislation becomes a very, very, important source of law because of the emergence of a state. So the part played by the judges in the struggle between the prerogative and Parliament enabled them to preserve in their hands a considerable measure of power. And one aspect of which is that what becomes law is their interpretation of a statute through the operation of stare decisis, which is a kind of hierarchy of court which is maintained there. So it has been put very beautifully by Lord Delvin, how he sees the role of judges in the realm of interpretation. So if you see, he maintained the law is what the judges say it is. If the House of Lords were to give an act of Parliament a meaning which no one else thought it could reasonably bear, it is their construction of the words used in preference to the words themselves that would become the law. So meaning thereby, it ultimately depends upon how a particular meaning is being derived by the judges from their own approach that makes sense in respect to any other thing. So in this way, the judicial doctrine of stare decisis has become, or you can say has come to be superimposed upon the doctrine of the supremacy of the crown in Parliament. So whether we are always aligned by the intention of the Parliament, that is one question which we always discuss, that yes, to find out what is the intention of the Parliament, we always adopt various kind of approaches, may it be literal rule of interpretation, may it be golden rule of interpretation, so on and so forth. So just inquire into whether that intention of the Parliament which we are always looking at, whether that is meaningfully exercised or that is being partially exercised. So take condition like when confronted with the task of interpreting a statute, judges say that their task is to ascertain the intention of the Parliament as can be gathered from the meaning of the words used. So this quest is no less elusive than the search of ratio decidendi for a case. So this is not a very clear-cut, assertion by the court. They are really doing that while exercising their power of interpretation of any particular law. Whether they are delving into to find out that very intention, and whether that very intention is very easy to find out, that is a very tricky thing. It is not that much clear. So for instance, there are certain situations which we must discuss, that how and why it is difficult to find out the intention of the Parliament. So for instance, where Parliament enacts a provision on a mistaken view of the law. As you all know, parliamentarians are also open to commit mistakes. So sometimes, suppose a condition where Parliament enacts a provision on a mistaken view of law, the courts will give effect to it according to what the law really was in their view. So here you see the discretion of the courts. Here you see the discretion or autonomy of the judges, that they look into whether if anything is being wrongly, you can say, framed by the Parliament, then when it is encountered through those kind of, you can say, laws placed before the judges, what they really do, they try to provide a meaning, or you can say effect, to a provision on a mistaken fact of that very legislature, to give effect to it what the law really was in their view. So they apply their own understanding to it. So this may be a byproduct of the rule that express words or necessary implication are required to change the law. So, such being the case, the point is, if Parliament did take a mistaken view of the law, in what sense are courts giving effect to the intention behind the enactment? So, reference to intention here in this very case seems very, very superfluous, because they are not actually abiding by it because it was wrongly or mistakenly given. So what they are gathering is not the intention, truly speaking. Secondly, whose intention is it which we are going to pay heed? So if you just inquire into that, you will find that it cannot be intention of the body which may have recommended the measure, such as the Law Reform Committee, nor of the draftsmen who are drafting the law, nor even of the members of the Parliament who voted it through. And the reason is that for a good many of them may not have attended on that day when the law was made, or may have voted only in obedience of a party dictates rather than their own will or exercising of their own free will. An act is the product of compromise. So because of this deficiency, one can say that when the act is made, it is not made truly by the intention of all the, you can say, legislatures and many other things which are being ideally posed, but an act is the product of compromise and the interplay of many factors, the result of which is expressed in a set forms of words. So you can say that ascertaining the intention of the legislature therefore boils down to finding the meanings of the words used. So you can in other way you can say that it is the intent of the statute rather than the intent of the Parliament which is in question. So one can contend this very thing, that whether the term legislative intent or the intent of the statute which has placed before the judges in the form of law, that materials most. So these are various, complexities, though the things are pretty recognized, that we always, inclined to the legislative intent, and in what way inclined, there are various practices which we have to talk about. But whether they are really is being done, they requires a quality check, they requires a fact finding. So because of that, I am making it clear before you, because so that you will be very, very clear whether the things are that much simple or ideally placed, those things which are ideally placed meet the practical reality or not. So you must be very clear how that has been applied. So further difficulty arises from the fact that what is the different terms means, what is the term meaning conveys, and what is the term intention conveys, whether both are the same or both have a different, you can say, understanding. So if you go by that, so does the present case falls within what the legislature meant to refer to by the wording it had used in form of reference, or does it fall within the purpose which is meant to accomplish? So one which is referring to the words which are used in legislation, that is more aligned to what it means, and the other thing is the purpose which is being there. So the two words, the two methods of treating a statute represented by these questions might be designated respectively as interpretation and construction. So whenever you are referring to some words which are used in the statute, that may be more and more directly connected to the interpretation. And when you try to venture outside of it, or you can say a little bit, you can say flexible regarding that, and try to find out the purpose, then you try to construct something, and that may be coming under the head of construction. So interpretation is more and more inclined and directed and restricted to the words which are being there in the statute, while construction gives a little bit more autonomy to judges to venture out and try to bring in something which is very much aligned to the purpose of the legislation. So, but the activities of the judiciary cannot be separated in this way, for the distinction between interpretation and construction is not that clear. It is ambiguous, it is sometimes, confusing also. So where language is equivocal, the decision whether the wording was meant to refer to the situation before the court, which no one may have contemplated at the time of the passing of the statute, inevitably imports a measure of construction. So suppose if something is required to be provided by the law but has not been provided, then the judges have that very space to venture into that what should be that kind of, you can say, concept which must be bring in. So that may be coming under the term construction. So in such cases, it is difficult to see where interpretation leaves off and construction begins. So while determining what is the legislative purpose, this would appear on the face of it to permit a court to venture outside the enactment for available evidence as to the policy behind it, so that the wording may be constructed in the light of this. So the practical question is how far. Now the question comes, like, you are giving that very autonomy, you are recognizing the autonomy of the court, that in certain situations, if something is not provided by the legislature, it can venture out to find out some other evidences to bring in. So while doing that, whether it is all free to do whatever it seeks to do or whatever it wants, or there is certain limit to even venture out of the legislative text. So here the practical question is how far a court is expected to go in search of such evidence, for without some limit, the inquiry might be pursued to unreasonable lengths. So what was the trend of the English tribunals? We must pay heed to that. English tribunals have evinced reluctance to venture outside the enactment itself. So they are pretty restricted to go that much outside of the given text, which means that its wording is to be construed in the light of the policy only, insofar as this can be gleaned within the four corners of the statute. So the extent to which you can venture must be restricted to the policy, and it must not go beyond that, the policy behind making that very law. So you venture to get into that, and then you can construct something, but you cannot venture that much where you can just negate that very limit of the legislative framework. So this limitation narrows still further the distinction between construction and interpretation. So another difficulty which comes from this fact that the statute seeks to control the future. Whenever you are restricting too much judges to, restrict to the legal text, so it always makes an effect how the laws are made. Sometimes laws are made in a way where they provide at most flexibility to the judges, because certain things are willingly not defined that much, because to meet the certain future eventualities. Like if you try to catch up in a new reality, you need some flexibility when the term is not defined. So there you have that very scope to define it in a given situation, according to a given situation. So because English judges or tribunals, they try to restrict themselves to the text more and more, so there was a very new tendency which brought in lawmaking, and the laws were made more elaborative, more explicit. They were dealing with all the nitty-gritty, so that nothing could be left from the realm of the legislative framework. So when legislature started doing this thing, then it is but obvious that the scope of the interpretation was a little restricted. So when we encountered this very thing, then another difficulty which started to arise was that the statutes seek to control the future by using broad terms of classes and categories. So these are man-made and there are inevitably causes omissi, so that a measure of discretion is imported into every decision as to whether a provision applies to the case in hand or not. So this was one trend. The other trend was nor do so to negate, or you can say to get rid of that very space where causes omissis were rectified by the judges, that whatever not being provided by the legislature, that has been provided by the courts by interpreting it, that very scope has been diminished, or you can say restricted. So nor do words have proper meaning. So this is another thing, another you can say most problematic thing in interpretation of a statute is that a word has so many meanings. It conveys so many meanings. So if you have defined a meaning in your interpretation clause, that is fair enough. But even then, sometimes it has more than one meaning. So how can you construe it? How can you interpret it? That is another very important aspect to look into. So nor do words have a proper meaning. A word may bear the meaning put upon it by the user, that understood by the recipient, or the usual meaning provided to it. So it means to say there are three players. One who is delivering the word, that is, if you take the example of parliament, I mean, if it tries to provide that. And the other one who is the recipient, who is taking it. And normally, ordinarily, what the people, I mean, convey through that word, that may make sense. So there are three things which comes into picture. So the last is, that is what what is the ordinary meaning of that very word, or what is the usual meaning of that very word. So the last is a compromise between the first two, how it is being understood by the a person who is conveying it, and the other one, I mean, the person who is using it, and the other one who is receiving it. So it's a kind of compromise between the first two, and is complicated by the fact that although most words do have an area of agreed application, they are also surrounded by a hinterland of uncertainty, which is where dispute arises. So this is a practical, you can say, impediment because of the imperfection of the language. So there is no one legislature or group whose assistance can be invoked, and it is obviously impractical wherever a statute comes up for consideration to ask members of parliament to elucidate what they individually or collectively had in mind. So the people who are delivering that word, if it is very practical, given the fact that those parliamentarians are, I mean, not intact always that to respond to you, because if it is an old legislation, they may have died, or if a very new situation is there, they are not there. So it means to say that how can you ascertain that what they really mean? So it is sometimes very impractical to ask to the parliament what they really meant. If you ask to the current parliamentarians, they may have a different kind of approach to that. So parliament is not considered to be an entity which can respond what they really mean, but this very task must be given to judiciary, that they can, I mean, derive that very meaning through that. So moreover, in case of antique enactments, as I said, that very old enactments whose framers have long since disappeared, the present member of parliament are in no better position than judges to explain what their predecessors may have intended. So it is the judges on whom the task devolves to ascertain the meaning as best they can. So judges are being considered more competent in that sense to take that very meaning. So fact finding and premise finding are another few things which they pay heed upon, the judges. And here In cases of doubt, which are the ones that present difficulty, it is not possible to separate the settlement of the major and minor premises, and fact finding and premise finding are interrelated. A court hears the evidence and determines the facts, and any doubt as to the scope and applicability of a given statutory provision may well be resolved by the view taken of the facts. So discretion, even in the application of a statute, is unavoidable because judges are there to apply the law in a given fact. So this is the kind of exercise which they can properly exercise if there is some sort of discretion which must be placed to the judges. So this discretionary element is given another slant through the relationship between courts and parliament over the centuries. So what was this kind of relationship, whether that was a very healthy relationship or there is a tainted relationship, or you can say a relationship which has always been in tussle. So you can see the discretionary element is given, the tendency has been on the whole towards a restrictive rather than a liberal exercise of discretion, which prompted a famous jurist Pollock to comment like this, that what is the attitude of the judges and how they do. So the attitude of judges cannot well be accounted for except on the theory that Parliament generally changes the law for the worse, and that the business of the judges is to keep the mischief of its interference within the narrowest possible bounds. So here you can say there is a very little, you can say, scope which has been provided to the judges, that they may not make unnecessary interventions when it comes to interpretation, when the things are very clear, and the other thing is when the things can be more clear by the Parliament rather than the judges. So in course of time, judges ceased to partake in legislation. Let us take a little bit history on here, like what was being done in British system a little previously, so that will make it more clear before you that how the power of discretion of the judges has been tremendously, you can say, decreased or restrained or restricted. So in the Middle Ages in UK, it was felt that the task of interpreting the law should be discharged by those who ordained it, for the very word interpretation connoted evasion. Parliament meeting a random was hardly the body best suited to do this, and judges were the persons on whom the responsibility was placed. Why? Because the need for interpretation more often than not arose before them, and more especially because at that time they took part in the legislative process. So because they are encountering with the various cases on daily basis, so they are more attuned to it rather than the Parliament, which once makes the law and then leave it for the judges to decide. So primarily in those days, judges were proactively involved in the law making also, legislative process also, if I can say. So do not gloss the statute. Hangman CJ admonished counsel that for we know better than you because we made it. So because they were involved in that very legislative process, so judges take that very stand that for we know better than you, we made it. So in course of time, judges ceased to partake in legislation and so lost their knowledge of the background and context of statute. So slowly they have been, restricted in that realm, and they were no more a part of, you can say, legislative process. So with the rise of the Court of Chancery, the common law courts may have felt inclined to relinquish to it the exercise of discretion in interpretation as well as in other matters. So the attitude of judges shifted in this way to something more like what it is today. So a statute was viewed as a text and judges could only infer the policies of the parliament from what was said in it and not beyond that. So this was a very great development where judges were restricted to go maximum to the policy and not beyond that while interpreting the law, and they were meant to be restricted to the given letters of law. Another historical development started with the fact that much early legislation was concerned with special privileges and particular derogations from the common law. So this should be set alongside the belief which then prevailed that common law was self-sufficient and ought not to be interfered with lightly. So the penalties of the criminal law too used to be among the most savage of their day, and the growing humanitarianism of the age made judges interpret penal legislation more narrowly than they might otherwise have done. So this was a kind of restrictive attitude towards statute induced by these factors has an unfortunate effect. The statutes of the 19th century came to be drafted in meticulous detail, as I mentioned you before, so as to provide for every conceivable contingency, since judges could not be relied on to help out with the omissions. Causes omissions was not improved or rectified by those judges, and because of that they have very little space, and they were meant to restrict themselves to the given letters of law. So this obedience of detail only inspired still more restrictive attitude. So for Parliament was taken to have specified everything that needed to be covered, and a causus omissi was assumed to have been intentionally left out. So the point shows, incidentally, how helpful the phrase intention of Parliament is. So different influence in more recent times has been the ever increasing regulation by statute of more and more spheres of activity, which has sometimes inspired in courts a desire to preserve the common law from being engulfed. So as you know, too many laws sometimes are problematic, and too many provisions are sometimes problematic. They give you less flexibility, as I said, to evolve the law. So in that way, if you are doing that you are providing everything in the law, every nitty-gritty in a very restricted manner. Once you have defined, you are not open to how it could be defined further. So because of that, Lord Tucker has made a kind of comment like this: it appears to me desirable in these days, when there are in existence so many statutes and statutory regulations imposing absolute obligations upon employers, that the courts should be vigilant to see that the common law duty owed by a matter to his servants should not be gradually enlarged until it is barely distinguishable from his absolute statutory obligations. So moving further, a decisive part is also played by a degree of sympathy which the courts entertains towards the objective in view. Judges do weigh up considerations of social and individualistic policy, and the balance does not always work out in favor of administration. So this is a very tricky situation at that moment. It was not that very simple to make a kind of balance in that way. So it has also long been the fashion to treat statutes and other documents alike. This is another, you can say, fallacy. You can say a kind of thing which could not be that much appreciated, that both the statutes and the documents were taken alike, though there are significant differences between a document and a statute. So the unhelpful attitude towards Parliament may also be a carryover of the different kind of doctrines, where doubts arises the words must be construed most strongly against him who uses them. So if you see it, you will find that the aversion to giving an appearance of acting outside the judicial function by legislating attributable perhaps to the doctrine of the separation of powers, may also be, responsible for that, that the rigid distinction between lawmaking and interpretation of law and how that could be taken care of. So that is also one of the reasons to bring in the rigidities in that way. So the present state of statutory interpretation suggests that something is amiss with the judicial approach to the whole exercise. So statutes and documents, we have to look into it. The statutes are designed to operate over indefinite period of time, so they should be viewed in a continuum, in a continuous process, you can say, and once it is being established, it is being taken care of a long time, and it is supposed to work for a long time. Unfortunately, the reverse has been the case with the documents. So the distinction may be expressed by differentiating between the referential approach as to what statute means, that is, what is words referred to here and now, and the purposive approach as to how it is to be applied. So there are two approaches, referential approach and purposive approach. When it comes to referential approach, it is more inclined towards the literal or plain meaning rule. On the other hand, the other approach, that is purposive approach, has led to the growth of various other rules of interpretation, starting from rule of mischief, golden rule, and then purposive construction, and then beneficial construction, and so on and so forth. So there are two kind of things. One is a referential approach and the other one is a, you can say, purposive approach. So application is a continuing process, and the application of a provision to a particular case is only one step in a journey. So there are so many limits, there are limits to continuous adaptation of the statutes which are not easily specified. So it should stop sort of altering the character of a statute, for example, changing procedural provision into a substantive one, or the introduction of the whole new doctrine. So now this is the story how various things, how various you can say terms or various jargons which are encountered in the process of interpretation could be dealt upon, and how the various phases of you can say history they have contributed into it, and how the various political setups in a particular country may also make an impact on that, and they all contribute how an interpretation could be made in a given country. So the policy of a statute may be likened to its plumb line extending into the future, and the construction placed on it, its wording should be in accordance with that very policy. So this method of approach is becoming more fashionable, but it has not been so in the past, because there has been too little appreciation of the fact that statutory regulation continues and has temporal extension. So that has been changed. Nowadays you see a very kind of liberal interpretations which are being made, where these are more and more venturing out into adducing the evidences to bring in something very meaningful to the law. So instead, the tendency has been for cases to be decided on a moment-to-moment basis, as I said, from case-to-case basis, with the result that the ins and outs of the lines of the cases or scores of the statutes have made this one of the sorriest corners of British jurisprudence. So the things which were defined in that manner, which was very restrictive to the judges, was not that much abided, if you see, and then various different kind of, you can say, rules were applied given in a particular case. So by being these things in mind, one can be very clear about this thing, that there is no single set of rules of statutory interpretations. It would be truer to speak of conflicting approaches and guidelines, largely supported by dicta, and one cannot confuse that there is one single rule which can govern these kind of affairs, or very well defined rule which could only be all pervasive. So there are different rules for to meet different situations, and one has to bear in mind this very diversity. So it must be, there is a quote by Lord Du Para who said, "It must be remembered, however, that the courts have laid down indeed not rigid rules but principles which have been found to afford some guidance when it is sought to ascertain the intention of the Parliament." So another quote I must provide here, that is, a court invokes whichever of the rules produces a result that satisfies its sense of justice in the case before it. So case to case approach, where different kind of rules of interpretation could be invoked as now the rule, now you can say it is a kind of practice which is being prevalent right now. So having said that, I hope that I have been able to provide you the nitty-gritties of the, you can say, various components of statutory interpretation and various confusions which may arise in this very realm. So if you grab it properly, you can grab the further discussion over the various rules of interpretation. And I hope that I have already taken up various kind of rules of interpretation. So we will be catching up the various aspects in the coming lectures. Thank you, and thank you very much.